I've built my career doing what I'm doing. Okay, next slide. There we go. So just a little bit of an agenda. Nothing too crazy for today, but this is kind of what we're going to go over. And if questions come up that while I'm talking, feel free to put those in the chat or voice them or whatever. Or we can just hold questions to the end. That doesn't really matter. If you guys get sick of me talking, just interrupt me and we can take questions to sprucing it up a little. But you'll see in the accompanying slides that there's just kind of it's very, very high level basic information that kind of goes through what we face from the employment based immigration end, and specifically from an employer. So next slide. So this is one of the reasons why U.S. immigration is the challenge that it is, the mess that it is, and the frustrating thing that it is, because there are many different government agencies involved. It's not just one government agency getting a piece of the pie. And when foreign nationals come to the U.S., depending on why they're coming to the U.S. and what they're going to be doing, at some point they could very easily have to endure some type of exercise with each of these government agencies. For many people that just come on an F1 and they're here just as an international student, their only exposure so far might have just been to the Department of State, which is the one that's issued the visa. And perhaps the I-20, which is actually administered through CVIS and ICE, which is part of the Department of Homeland Security. But as individuals progress in their career and their life in the U.S., they will encounter these other government agencies. And so that's why it is very challenging to get through different steps of the process, because it's not just one entity necessarily taking care of someone's case start to finish. There are just so many different moving pieces involved with getting through the immigration process in the U.S. Next slide. So these are the different kinds of non-immigrant visas that require some type of employer sponsorship. And these are the ones that I'm just putting these up here, are the ones that we encounter the most as an employer. This is probably pretty common across the industry, whether it be Bayer or Amazon, Microsoft, Google, whomever it might be. These are the ones that employers are going to see. And so this is just an example of really the bulk of what employers encounter. We'll get into the F1s in a little bit more detail, but this is, they get, the F1s get 3 tiles because there's 3 different elements to an F1. Next slide. So then these are the other types of non-immigrant visas that require some type of employer sponsorship. A J1 is probably the one that maybe that's questionable, just because of depends on who administers the DS 2019 and that program. If it's at a university, it's is it technically does an employer need to sponsor that? And the answer is yes, because academic training requires employment at an employer. TNs are another category where individuals think they just need a letter and they just take it to the border, and they get the TN that way, but they have to have an employer willing to actually offer that letter for them. But these are the other typical scenarios that require some type of employer sponsorship. Next slide. These are the other types of individuals that can be employed in the U.S. in some type of non-immigrant capacity that employers will also typically see. And again, all of these require some type of separate work authorization, with the exception of the L2, E2, and E3 EAD. There was a recent change in 2021 that resulted from litigation. So when the Immigration Service gets sued, it usually results in some type of change. That's the only way a lot of things get changed nowadays, is the government gets sued, and by default they're like, I guess we're going to have to do something to change how we administer these benefits. So that's a category that actually used to require separate work authorizations, similar to the H4 or J2 EAD, but they no longer do require that separate work authorization. And then individuals that are applying for adjustment of status, whether it be based on an employment-based or family-based application, are also, given work authorization. And depending on the kind of work authorization that they have, and if it's based on an approved I-140, employer sponsorship could actually be required for that type of scenario, because that individual actually has to port to same or similar employment if they have a pending I-45, and an employer has to be willing to file a 40 notice for them. But that's something that does happen, but that's just another scenario where someone could potentially need employer sponsorship. But traditionally speaking, these are the categories that don't need employer sponsorship. Next slide. So this question comes up quite a bit, just in general conversations that I have with employees that I support, and then in the course of getting this presentation ready to go, some of the questions that had come in ahead of time, and I'm like, well, okay, I'm just going to be very blunt and straightforward. And I tell this to employees that are hired, and we run into challenges with the H-1B lottery. And I will tell them the biggest roadblock right now, unfortunately, is for individuals born in India or China that only have master's or bachelor's degrees, and they do not have a STEM degree. 1 year is not enough time to essentially move on to some other type of non-immigrant status that's going to allow that individual to keep working. And this has to do with visa retrogression, which we'll cover, in a few slides from now. But it's basically, there's no way to take someone born in India or China to an employment-based green card if they're in second or third preference category for purposes of the green card. So that's unfortunately just the environment that we're in now for individuals born in other countries. There is some retrogression, but it's not as severe. People do ask me, what's a typical lifespan for someone that's born in India that only has, let's say, a master's degree in computer science, and they're a software developer or something like that, and their only choice is second preference India. How long does it take? And that doesn't include the time they might have come here as an F1 and they did their degree. So typically it'll take 12 to 13 years for someone to get that green card in second preference India. China's maybe 5-6 years, so it's not as bad, but there's not enough time to get someone through the green card process if they're EB2 or EB3 India or China before their F1 EAD expires. So I like to just point that out ahead of time. This is an ongoing struggle for companies everywhere. It's not just specific to where I work. It's just the specific demographic that is the most challenging right now to try and manage through. Next slide. So the H-1B lottery is like the bane of my existence right now. For most companies that hire foreign nationals, here's just a general snapshot of what we go through as an employer when we're looking at someone that's going to be subject to the H-1B cap, which for for-profit employers, there is a cap of $85,000 per federal fiscal year. It has been met every single year, I think, since 2013. I remember not long after I started at Bear that there were still H-1Bs available through the summer of 2012. But since 2013, it's consistently been met. Back when there was a statutory change in 2000, I think it might have been then, that they had raised the numerical limitation to 165,000. And then it kind of sunset every year after that. It's been 85,000 for forever. And clearly it's not meeting the demand of employers to be able to staff their workforce, but this is what we're stuck with. And the only way that can change is if Congress actually does something. So other challenges with the H-1B is if you don't submit a registration between the registration period between March 1 and roughly March 17th, you don't get to submit another registration until March of the following year. And then if picked, it doesn't become effective until October 1 of the following year. So for individuals that that have a registration submitted, let's say in March of 2023, and if they're not picked, they don't get another shot until March of 2024, and then it's October of 2024 before they can even go into H-1B status. So there's a lot of management that goes into someone's current non-immigrant status. We'll just focus on the F1s for a minute, to see if there's enough time on their EAD, and if they're going to get a STEM extension, because we've got to be able to make sure that there's continued work authorization for that individual. Other things to keep in mind about the H-1B lottery is H-1Bs in general, the role has to require a bachelor's degree. So there's been, in the last couple of years, employers have wanted to eliminate degree requirements and only focus on the experience that an individual has gained, not realizing that's going to exclude individuals that need an H-1B and other roles that don't actually require a bachelor's degree. So there's a mismatch there between employer needs and what the U.S. government will allow. Next slide.
Cece, I'm also not sure your voice. I don't know if it's just me, but your voice was coming in and out a little bit for the last couple of seconds. Was it just me or was it everybody?
Everybody.
Oh, sorry. Is that any better?
Yeah, that's better. Yeah.
I'll just talk directly into the speaker.
Talk into the speaker.
I'll just glue my face to the screen. So this is the latest H-1B lottery woes. For those of you that follow anything related to U.S. immigration closely, this has seen a lot of attention this year compared to prior years. And this has to do with the fact that there was about, I think it's more than half of the registrations that were submitted were not actually what we would consider legitimate registrations, meaning that there were multiple registrations submitted for multiple beneficiaries, or meaning that there was one beneficiary, but there might have been 6 or 7 registrations submitted. And that skews the selection rate of what's available. And so this year, the selection rate for most employers was about anywhere between 15 to 18%. So it used to up until about 3 years ago, it used to be about a 40% chance of getting picked. And now it's this year alone, you have about a 15 to 18% chance of getting picked. So it's got a lot of media attention. There's fraud investigations ongoing into this. I have my own personal beliefs on what the USCIS is going to do and not going to do about the H-1B lottery woes. But apparently they're trying to find ways to crack down on some of the fraud that's ongoing. So this has been a very challenging year for employers. Next slide. So now we're going to get into some of the challenges for F1 students. And the one that we see a lot is sponsorship. How should F1 students answer questions about sponsorship on employment applications? Some individuals say, no, you don't have to indicate you need sponsorship. You have OPT. That doesn't require an employer to sponsor you. That's correct. But many times the questions are worded in such a way that it's either now or in the future do you require employer sponsorship. And the question should be answered as yes. Even though it might, certain employers, algorithms and data mining that they do might exclude you from getting through the next step of the application process. Trust me, if you are an employer and you said no, you don't need sponsorship, and you missed the window for the H-1B registration for the lottery because no one knew about you because you said no, you didn't need sponsorship, that creates a lot of extra fire drills. So we always encourage the F1 students that come, whether it be interns or individuals that we know about, that they should be indicating yes, they do need employer sponsorship when asked. Next slide. There are some questions that came in about day one CPT. And so there's a couple slides I devoted to day one CPT. I'll just kind of gloss over this. For any F1s, there's essentially three ways to work off campus. On campus, you're authorized for the 20 hours a week, but off campus, there's day one CPT or regular curricular practical training. So an internship over the summer or regular semesters, That's one traditional example of CPT. Then there's OPT, and then there's the STEM extension. So those are the three types that we will typically encounter. Actually, I should say four, because there's curricular practical training and there's day one curricular practical training. But it ends up being it's the same acronym. Next slide, please. So what happens when someone has day one CPT and they're wanting to change their status to H1B? Let's say they got selected in the lottery and everybody's super excited and yay, we have a way to hire someone and get them off their day one F1 CPT. This is the kind of information that the USCIS is going to be looking for when someone is using day one CPT. It is going to become harder now that the flexibilities for online distance learning is going to be eliminated starting this fall. So there was a little bit more flexibility the last couple of years due to COVID, but now there's going to be the requirement to actually attend classes in person. And so this is just an example of what an individual needs to be prepared to be able to prove that they were actually maintaining their F1 status and they were actually pursuing a degree. Next slide, Aditi. Here's more. So these end up being about 3 pages of information that the USCIS requests when they are looking for day one CPT proof. So this is I just sanitized it and wanted to show individuals that this is not a myth, that it does happen, that they do look for this kind of stuff. Next slide, please. So now we're going to get into some of the alternatives. What happens if someone's not picked in the lottery? And they maybe have, let's say they have 2.5 years left on their F1. They've got, they're going to get a STEM extension, and they've only burned through a couple months of their OPT. So we'll look at, an O1. Does someone have the right background and credentials to get an O1 visa? And so this is unfortunately something we've had to look at a lot closer the last couple of years because of the challenges with the H1B lottery. I'm not going to go into each and every single bullet point, but I did put asterisks next to the ones where these are the categories that carry the most weight, at least in my own experience of what the USCIS is going to want to see. Because many times, the more an individual publishes, that means the more times their work's going to get cited. So then they're going to fill in another category. So now they've got publications and citations. And then if their publications result maybe in invited presentations. And now they're going to have original contributions. And so they just kind of build on each other from that respect. So I wanted to point out that those 4 criteria are usually the criteria that individuals can meet, again, depending on their background and what they've done in their academic career. Okay, next slide, please. So there's just some more general information about the O1. They are not like, just don't sit down and one day you're like, I want an O1 visa, and the next day an employer files it for you. There is a lot of heavy lifting involved from the employer and the beneficiary. They do take a while to put together. So they're not, again, I would say if the case is strong, it's pretty straightforward, but if the case is not strong, it's a little bit more challenging, because then we have to figure out how we can use the information that we've been giving to try and highlight some of the criteria that they are meeting. So there is some challenges with doing an O1 and being successful. I did put that last bullet on there. It's not always about how many publications or citations the person has. If they've only got 1 publication and no citations, okay, that's probably not going to work. But if they've got 5 publications and they're all in science or nature or something like that, and 50 citations, and they've all been cited by individuals from around the world, that's going to carry a lot more weight than someone with 10 publications, but they've all been from low impact factor journals, or maybe not, they're journals that aren't international in scope or something like that. So we take a very holistic view of someone's background to see if there's enough there to work with. Next slide, please. Make sure I'm doing okay on time. Another alternative to the H-1B is an L-1. So for global companies that have operations around the world, this does not work if there's only a U.S. employer. That there has to be a legal entity overseas to be able to use an L1. The nice thing about the L1 is that there's no quota, meaning that employers can use L1s throughout the entire year. There's that flexibility to be able to move employees back and forth. But if someone's not picked in the lottery and they're starting to run out of time, is it going to be feasible to maybe send them overseas for a year and they work for that legal entity overseas for a year and then transfer them back? So a lot of employers will look at this as a potential option, depending on where the individual's from and if they're willing to go overseas, or if they can go to a country where maybe obtaining work authorization is not as challenging. So an L1 is another category that we'll look at as an alternative to the H-1B. And recent, probably within the last couple of years too, individuals have looked at who are currently here, maybe on an H-1B, looked at going overseas for a year if they're a manager of some sort, and they go work overseas for a year as a manager, and they come back as a manager, then that puts them into the first preference category for purposes of the green card. So that's something that we'll look at too, just from a green card perspective, not necessarily an alternative to the H-1B, but that's also something else that employers can utilize if need be. So next slide. Yep. And then the other part of the analysis goes into can we take someone directly from, let's say, their F1 directly to a green card? What are the options available? Again, India and China, they're completely, it's like there's two buckets. So we got India and China, and then everyone else over here. That's how the visa will have been set up too, essentially. But we look at those possibilities. If it's India or China, it's only going to be an EB1 that's going to do them any good. An EB2 or an EB3 is not going to do anyone from China or India any good. So we'll look at if they're eligible for an EB1B. If they're married, I want to know about you. What's the status of the spouse? Is the spouse also from a retrogress country? Or is the spouse happen to be born in Nepal? You'll see that on your screen there. If a spouse is born in Nepal or Kenya or France or somewhere else, then the individual that was born in India, let's say the employee born in India, actually is no longer charged to India. They are now charged to Nepal or Kenya. And so they're no longer subject to visa retrogression. And so it is possible then to take them directly from an F1 to a green card if their spouse is from a non-retrogress country. If there's a spouse, is the spouse further along in their green card process? Does the spouse have an approved I-140? Could we look at putting someone on an H4 EAD if the spouse does have an approved I-140? Spouse, are they from India or China? So what kind of challenges are there? Is the spouse a U.S. citizen or permanent resident? We get some of those too, where a permanent if you do an F2B spouse of a permanent resident, well, how far back is the wait for someone that's marrying a permanent resident? It's not as long as it would be in the employment-based process. So then we look at that too. So there's all these different scenarios that employers will look at to try and make sure that they can keep that employee in the U.S. and working. And then I just wanted to add this last bullet point for individuals that are maybe pursuing a PhD, or maybe they're in a master's degree, but maybe it's a master's degree that requires more publishing and more authorship than normal. Keep everything that comes across your desk for purposes of using that later on for an O1 or EB1 or an NIW, whatever it might be, because you're going to need it. You're going to need that stuff later on to prove that you've been sought out as an expert in your field, or individuals want to know a little more about your research. And so just keep that information. Don't just let it sit in your inbox and then you graduate and then you no longer have access to it. So keep that somewhere else to where you can access it after you graduate. Next slide, please. And so this is a little bit more about the different permanent residency options when we're looking at the different categories that we could go into. I'm not going to focus on the EB1A because that's a self-petition category, and that's not something that some employers won't necessarily support that because, again, it's a self-petition, and that's the hardest one to meet. But the EB1C is what I referenced earlier when someone's here and they don't want to wait 12 years to get a green card, so they're going to go and they're a manager overseas and they come back as a manager in the U.S. So an EB1C, but a typical trajectory for someone that's EB1C would be we're bringing them from overseas and then they're coming here as a manager and do the green card that way. And then there's the EB1B outstanding researcher. In academia, it's going to be either a researcher or professor, but in industry, it's just going to be a researcher. But that's the burden of proof is a little bit less than for an EB1A. So EB1B is the other common category within the EB1 that employers will look at doing. Next slide. And this is a little bit more about EB2. So when I said that doing an EB2 for someone from India or China for an NIW, for instance, it doesn't do any good because it's still EB2, even though national interfavorite sounds like it should be a higher preference than EB2. It's not. But for individuals not from India or China, it is a viable option for purposes of the green card, especially if they're having a hard time getting picked in the lottery and they file it early enough. They could actually go directly from their F1 onto a green card based on an NIW approval. And then the other common scenario that employers utilize a lot is EB2 and EB3 perm. So that's administered by the Department of Labor. So on that first slide, I said the Department of Labor is going to get their hands in it somehow. They get their hands in it when employers are doing perm applications. And the only difference between the EB2 and the EB3 is the type of degree or experience required. So to do EB2, it's a master's degree or a bachelor's degree in 5 years post-bachelor's experience to get into the second preference. And then for an EB3, it's a bachelor's degree and less than 5 years of experience or some years of experience. So those are just the only differences between those two types of firms. And then I think, is that the end? Maybe I don't know if I have. That's the end. So I wanted to make sure that there was plenty of time for questions or comments. Yep. And so that's the end of my presentation. So I guess I'll just turn it over for questions.
Yeah. So the way I plan on doing it is I can, present the questions here one after the other, and then you can answer one by one. So the first question that we have in the chat is, it's from iPhone. It says, do Canadian permanent residents, not citizens, also qualify for the TN visa?
Unfortunately not. You have to be a Canadian citizen to be able to get the TN visa. So I think there's a requisite period of time you have to be a Canadian PR before you're eligible for citizenship. So unfortunately, Canadian permanent residency doesn't do anyone any good. Nor does Canadian citizenship if the individual is born in India or China. They still get charged in China even if they become a Canadian citizen.
So just to be clear, if you are a Canadian citizen, but you were originally born in India or China, you will still be treated the same way as an Indian or Chinese in the US.
Correct.
All right.
For purposes
so next question.
Yep. Okay.
Okay. Next question. Are spouses on H-4 visa eligible to work in the US too? Or they require a separate employer sponsorship and work visa to be able to work in the US?
So the only way H-4 individuals can work in the US is the H-1B principal applicant has to have an approved I-140. And then once once the H-1B holder has an approved I-140, that H-4 holder then can apply for employment authorization, which is a separate application process, takes several months to be approved. And then that work authorization is tied to the end date of the H-1B holder's work authorization.
Okay. Next question. Can parents be given H-4 visa or is it just for spouses?
Spouses and dependent children under the age of 21 are eligible for H-4s.
So no parents, right?
Nope.
Okay. So next question, can an employer sponsor someone with a STEM PhD on a J1 visa for a scientific project manager role rather than an academic postdoc role? Are J1 and H1B limited to academic positions?
Um, no. Typically J1s, when they finish their degree or during the course of their degree, they're eligible for academic training. So it's kind of similar to the F1 practical training. If it's a PhD, they're eligible for 36 months of academic training. But they're not going to become eligible for the H-1B until if they have a 2-year residence requirement, then they actually have to have the 2-year residence requirement waived before they can become eligible for an H-1B.
Okay. And then the next question is, does the permanent residence possibility of an H-1B holder change if their spouse was born in India, China, and does the citizenship of the spouse have any weighing if they were born in India, China, but are actually... Okay, Yukti, you might want to unmute yourself and explain your question better here.
Hi, sure. Thank you so much. My question is, my partner is in the US. He has an H-1B visa currently. I'm outside of the US, and he's not an Indian or Chinese born person, but I am. If he was to apply for a permanent residency with me on his application, does the fact that I was born in India or China have an implication on his permanent residency possibility? And does the fact that I am not an Indian citizen, but I'm a New Zealand citizen, have any weighing on this conversation?
Oh, that actually ends up being good news, meaning that you're not going to be subject to visa retrogression. And you wouldn't be even if you were born in India and your spouse was born in, let's say it's the reverse, he was born in New Zealand, but you were born in India, then both of you would still get charged to New Zealand.
Okay. Thank you so much. Perfect. Sure. Thank you.
Okay. Up next is Sayani. Could you please unmute yourself and ask your question?
Sure. So I am on my first year of OPT right now. My employer agreed to file for my H-1B all 3 years if required. This year, I didn't get picked. Now I'm thinking, should I try to convince my employer to file for my green card, my EB-1B, or should I wait till my next year of H-1B? I mean, can they file both H-1B and my green card at the same time, or are they mutually exclusive?
So the thing about the H-1B is that it has no bearing on the green card process and vice versa. So the H-1B is one of the only one of two non-immigrant statuses that you can be what's called a dual intent immigrant, meaning that you can actually be pursuing permanent residency at the same time as holding that status. The L1 is the other category. So pursuing an H-1B and an EB-1B at the same time, there's not an issue with that. But depending on the individual's background and whether or not they qualify for the EB-1B, the other caveat with the EB-1B is you have to have 3 years of research experience, and you have to be able to prove that. So sometimes it's difficult for new graduates to have enough experience that would qualify as part of the EB-1B.
Would my PhD research count towards those 3 years, or does it have to be after that?
The most conservative way to do it would be after, so 3 years of experience post PhD. Otherwise, what happens is you have to be able to prove that the experience you gained while you were pursuing your degree was extraordinary, outstanding in some nature. It wasn't just typical regular research. So you have to go then back into your PhD research, if there's master's research or anything like that, and be able to prove that the research you did was essentially extraordinary, outstanding. Versus if you had enough time after your PhD, then you don't have to prove that. It's just 3 years of research experience.
Can I ask another follow-up question? I know there are more people with more questions, but
we are kind of
okay,
low on time. But
thank you so much.
Yeah. So Rohan, please ask your question.
Yeah, hi, Cece. I just wanted to ask, is there a dwell time, like a duration for which you have been in the US, after which you become more likely to get a green card or eligible to apply for green card? What is that? You mentioned something about 12 years waiting. What was that about?
The 12-year wait is the length of time it takes for someone that's established a priority date. And a priority date is established either by filing a labor certification of perm or an I-140, so that would be EB1 or an EB2 NIW. And then if someone files, say, an I-140 today, and they didn't have it's not based on a perm, then it would take roughly 12 to 13 years for that individual to actually get their green card if they're born in India and they're EB2.
Okay, thank you.
Mm-hmm.
Okay, Srinidhi, please go ahead and ask your question.
Yeah, hi. Right now I'm on my STEM extension visa, and I'm kind of looking for options to extend my stay in the country. Would applying for a B2 visitor visa do any good?
It would only allow you to stay in the country. You can't work on the B2. You can't do anything else. So you'd be sitting in the US, not able to work or have an income. So at that point, it's more of a personal decision.
Okay, thank you so much.
Okay, Sarah, please ask your question.
Hello, CC. This is Sarah. My question is, can you please talk a little bit more about why EB2 or EB3 isn't a good option for people from India or China?
So I'm trying to think of the quickest way to answer that. Otherwise, we could be here all day. So the reason for that is because of the amount of time. So based on Rohan's question, the amount of time it takes someone to get through the requisite steps of the green card process to the point where you can get work authorization. If someone has OPT and then a STEM EAD, they've only got 3 years of work authorization. It takes 12 to 13 years for someone born in India or China to get through a green card based on EB2 or EB3. So there's no way to cover that other 9 years of waiting for your priority date to become current. So that's the challenge with India or China, is because it takes too long to get through the requisite steps to get to the point where you can file the last step of the process and get work authorization.
Oh, okay. Okay. Thank you so much.
Mm-hmm.
So 1 second. The next person is EE or double E. Sorry, however you say your name.
It's fine. Thank you. Thank you so much. So I just wanted to know, I think I qualify for 6 or 7 of the extraordinary ability requirements. So I just wanted to know if it's okay to start from the O1 visa, and then once they get approved, I can, go to the EB1A, or should I do both at the same time, or should I just go straight to E1BA and apply? So what would you advise?
So it depends on how much time you've got to work with on whatever work authorization is you currently have. If you're running out of time and you need to continue work authorization, an O1 is probably going to be quicker to have your work authorization continue, because that can be premium processed. And the burden of proof is lower for an O1 than it would be for an EB1A. But the nice thing about the EB1A is it's a self-petition, meaning that you can do that completely on your own and migrate directly onto a green card from that. The O1 is going to require an employer to actually file it for you. So again, it's going to depend on how much time you've got left on your current status and work authorization, and whether or not you can, if your employer is willing to do the O1.
All right. Thank you so much.
Mm-hmm.
Okay. So Shalvi Sinha, please ask your question.
Hi. So I had a question about O1. I'm on H1B currently. And I was reading up about O1 yesterday. So what is the advantage of applying for O1, and how soon can I get a green card if I get the O1 visa?
So the O1 is another non-immigrant visa. So it's not a pathway towards a green card. It just allows you to work in the U.S. For that specific employer doing that specific thing. The only benefit for someone I could see that's on an H1B and moving over to an O1 is if for some reason on the H1B you haven't been able to get an approved I-140 within, before you go into your 6th year of H1B status. So you're running out of H1B time. Otherwise, if you have an approved I-140 and you're on an H1B, there's no benefit to doing an O1. It doesn't get you any closer to the green card or get you any further down the road.
And a follow-up question, Cece, for you. So I've heard a lot of times about O1 and EB1A. So does O1 visa provide a good precedent to an EB1A, or like why do people prefer to go for an O1?
So an O1 has similar criteria that has to be met, but it's not as stringent as the EB1A. Just because someone gets an O1 doesn't mean they're necessarily going to qualify for an EB1A or an EB1B. So it's just it's similar evidence, but it's also different evidence, if that makes sense.
Yeah, sure. Thank you so much.
All right. iPhone, please ask your question. Okay. Looks like they left. Balaji, please ask your question.
I have one small question. So basically, I work somewhere along software development and data analytics. So I have like a master's degree and I'm an Indian citizen, but there isn't much scope for folks like us to work into research or publications. So what do folks like us have to do in order to meet the criteria for an O1 or an EB1A? Like, something other than those criteria that we can work towards?
So unfortunately, that's the crux of the issue. It kind of goes back to that one of those beginning slides. Unfortunately, that demographic that you were in is the biggest challenge right now, because there's not an individual just doesn't have the background and the criteria to meet an O1 or an EB1, but they're also they've also got some advanced education. So that is the most challenging demographic, because the options are essentially end up being limited. So depending on the employer, if the employer is a global company, you look at the L1. Is that possible? Does the individual, are they willing to take the risk and do day one CPT and go get another master's degree, or perhaps enroll in a PhD program, or return to their home country, or perhaps look at Canadian, doing an express entry and getting Canadian PR, and hanging out there for a few years, and maybe eventually getting Canadian citizenship, and then maybe a TN. But that's the demographic where the options are probably the most limited.
All right, sounds good. Thank you.
So we have 2 more minutes for questions. So we'll try to go through it as soon as possible in a smooth way. Akshay, please go ahead, ask your question. Okay, looks like Akshay is not here. Benita, please ask your question.
Hi, Sissy. I wanted to know, for example, if my employer has already started my prevailing wage determination, and because of the uncertainties, I decide to go with the EB2 NIW, the national interest waiver. Is it possible to file those two simultaneously?
Yes. Yep.
Okay, thank you.
Mm-hmm.
Okay, who's next? Let's see.
I think Akshay is here. Akshay is like, I'm here. I see that.
Yeah, I just saw it. Akshay, you want to go ahead and ask your question?
Yeah, sure. Thank you so much. Hey, CC, this is Akshay here. So, I'm running out on time on my H1B. It's expiring September 10th of 2024. The prevailing wage determination was filed January of this year. That's Jan 2023. So I'm assuming that everything could come in time, but I'm not sure. So if say the lawyer is saying they can even file the perm only by say January of next year. So do you think it's a sufficient amount of time to even get the perm approved as well as the I-140 by September 10th of next year? And if not, do you think switching to a visitor visa is a good sort of plan and then coming back on H1B?
Well, that's a pretty loaded question.
I'm sorry.
No, that's okay. We get that a lot. The first thing that you'd want to do is see if you've got any recapture time available. To see if you can extend. If your true 6-year maximum is September 10th of next year, if you've got recapture time that moves your max date back. So if you've got 2 months of recapture time over the last 5.5 years, your max date actually now is November 10th. Okay.
Okay.
So that would be the first thing to figure out. But that timeline's pretty tight. There was ways to have it done, but then you would be relying on the Department of Labor to actually certify your term when they need to certify it, and hope and pray that there's no audit for the term.
Okay. And to buy time, do you think maybe going on a visitor visa in like May of next year is a good sort of a option, or maybe
No,
June, July?
You can't work.
I know, but then if the I-140 does get approved, then they can do H-1B, transfer, and I can come back. Is that possible?
Well, these are it's a little specific questions, so I think you probably need to sit down with your employer and their outside counsel and maybe work through some of the other alternatives if you get down to crunch time and you draw the line in the sand at whatever date, and then start making decisions based on that.
Okay. Okay. All right. Thank you so much. Thanks a lot.
Yeah. Aditi, you wanna talk about the next event?
Yeah, well, thank you so much, CC and Kshitij, for doing this. This is wonderful. I do want to acknowledge that this was just the first brush. If this is the first time you're learning about the immigration process, you're not going to be able to get all your questions answered. And the beautiful thing about immigration is just like responding to your emails. By the time you have responded to all emails, a new email has come in, and now you have to go back to the same process. So if CC answers a question, that answer can lead to another question. So I want you to know that you're not going to get all the questions answered, but I do want to acknowledge how wonderfully CC has shared and diluted all these complex information to us. So I want to take a moment to thank you, and I would encourage everybody to please thank CC in the chat as well. And Kshitij too. I mean, he's a PhD student who is doing his internship and
candidate.
Time.
I just became a candidate.
Candidate, yeah, he is ABD now. So I do want us to acknowledge how much it means to the community for you to spend 1 hour of your day on a Saturday to put this together and answer our questions. So thank you so much, CC. I appreciate you, and I appreciate the PowerPoint. I'm going to share it all with everybody. To wrap things up, I want to share 3 things. Number one is, if you are not aware about the Slack community that we had created last year, this is the joining link. Please go ahead and join it. We have close to 2,100 members right now, and we always engage in conversations trying to bring clarity to this very complicated landscape, however unnecessary, that is immigration. The second thing I want to talk about is all these questions that you're asking, especially what CC said today, that the people who are at most risk and who need EB1s the most are people who have a master's degree and they work in non-research, non-PhD area. So if you are interested in understanding how can I, somebody who has a master's degree, still qualify for an EB1, I would encourage you to mark your calendars for the next week, Saturday. That is June 10th. We have Shantanu Joshi, and I'm going to put his LinkedIn profile on in the chat, so you can take a look at his LinkedIn profile and know exactly who this person is. So he's going to come and talk to us next week, Saturday, about how he qualified for EB1A after receiving an RFE that is requiring further evidence. So if you are curious about that, I would encourage you to come and attend that. And the last thing is, I'm going to share, CC, should I share your LinkedIn or no? Yes.
That's fine. Yeah, that's fine.
So if you want to sneak into CC's, don't spam her obviously, but if you want to sneak into her DMs and say, CC, thank you so much for all your wisdom. And for being the bad cop as well as the good cop, you can obviously reach out to her, and you can reach out to me as well. I also share immigration related content with memes on Monday. So if you want to laugh at your own misery, please come join us, because I do that all the time. It makes it a little easy to bear this burden on us. With that, I'm going to end the call. Thank you again, Cece. Any parting thoughts? Any last words of advice for all us immigrants?
Oh boy. So first, I do want to point out, based on the amount of questions that have come in, I'm more than happy to come back. And we just do an hour of like rapid fire. Like there's no presentation. It's just sit down and it's like, ask Cece anything. I'd be more than happy to do that. I'm just looking at some of the questions that have come in and I'm like, okay, there's a lot there to try and navigate through. So I'm happy to do that. If you want to have me back sometime.
It's on record. It's on record right now.